50616, Law Office of Ryan Downton versus Little River Healthcare. And we'll hear first from Mr. Downton.
May it please the Court. My name is Ryan Downton, and I represent the Law Office of Ryan Downton. This case is a textbook example of the need for judicial estoppel in our court system, arising out of an arbitration between the bankruptcy trustee for Little River Healthcare and Blue Cross Blue Shield of Texas. The trustee prevailed in the arbitration and then asked former Supreme Court Justice Harriet O'Neill, acting as arbitrator, to shift a contingent fee in the amount of 10% of the arbitration award in excess of $47 million to the defendant in that arbitration, Blue Cross Blue Shield. Justice O'Neill shifted $1.7 million following Texas Supreme Court precedent using a lodestar calculation. Following the arbitration, the bankruptcy trustee told the bankruptcy court that he did not, in fact, owe any contingent fee to the Law Office of Ryan Downton. This appeal followed. This case mirrors the procedural situation in two Fifth Circuit cases, in Re Superior Cruise Boats and the Republic of Ecuador v. Connor. In both cases, this court reversed trial courts for failure to apply judicial estoppel. Judicial estoppel requires a clearly inconsistent position and acceptance by a prior tribunal. Here both are clearly in play.
Well, I thought that former Justice O'Neill explicitly said she was not deciding attorneys' fees. What we have here is a contract dispute. We do not have the underlying dispute about how much money Blue Cross owed the debtor. We have a separate contract dispute between you and the trustee. When does judicial estoppel apply across disputes?
So it applies when the initial tribunal necessarily relied on an argument from the plaintiff in this case. A tribunal can only shift fees when fees are owed. If the tribunal shifts $1.7 million in fees, but no fees are actually owed to the attorney, then you've created a windfall for the plaintiff and reversible error. If you look at this court's opinion in Hall v. GE Plastic, it says judicial estoppel applies anytime a court necessarily accepted and relies on the party's position in making a determination. The court, in the same opinion, also notes that the doctrine may be applied whenever a party makes an argument with the explicit intent to induce the lower court's reliance. And that's what happened here. The trustee made an argument to induce the arbitration tribunal's reliance on the position that fees should be shifted.
What was your role? Your role in the prior litigation was that of a litigator and witness, is that correct?
That is correct. So in addition to their positions being inconsistent, they were necessarily accepted by the tribunal. This case mirrors a case from out of the jurisdiction, Barak versus Lafredi out of Illinois. In that case, there was also an arbitration. The plaintiff switched attorneys midway through the proceeding. In prevailing, he filed a request for shifting of fees with the arbitral panel. He obtained an affidavit from his original counsel, which he submitted declaring the amount of fees owed, which is exactly what happened in this case. And then the tribunal shifted a portion of the fees, but not all of them, to the defendant in that case. Following conclusion of the arbitration, the plaintiff refused to pay his attorney. The attorney instituted a separate lawsuit, and the court in that lawsuit applied judicial estoppel, finding that once you've argued to an arbitral panel you owe attorney's fees, you are bound to pay your attorney the fees that you told the tribunal you owed.
But we go back. You're not even talking about your contract, and your contract distinguishes between direct damages on the one hand and consequential and punitive on the other. Why aren't you talking about your contract? Since that wasn't decided by the arbitrator.
Sure, I'm happy to turn to that.
Good idea. Thank you.
So the contract specifies an award at fees of 10% of all consequential and punitive damages, which are further defined in the contract. In fact, the language says, for the avoidance of any ambiguity, consequential and punitive damages are defined as all damages other than direct damages, which are further defined as money the arbitrator finds that Blue Cross should have paid Little River for healthcare services provided to Blue Cross insurers. Here we have an unambiguous contract, and the court is bound by the terms of that contract. There are 3 categories of damage at issue in this appeal: prompt pay penalties, uncollectible patient responsibility, and prejudgment interest. For each, I think there are 2 questions for the court. First, is the category in question a form of damages? If so, is it money that Blue Cross should have paid Little River for healthcare services? For any item that is both an element of damage but not something that Blue Cross should have paid Little River, it's inappropriate to award a fee. Prompt pay penalties are damages, and they are not money that Blue Cross should have paid Little River for healthcare services. This court has previously certified a question to the Texas Supreme Court asking if statutory penalties are exemplary damages. In Walmart v. Forte, the Texas Supreme Court responded, we easily conclude that civil penalties are exemplary damages based on Chapter 41 of the Texas Civil Practice and Remedies Code. That chapter governs, quote, any action in which a claimant seeks damages. So this arbitration is subject to Chapter 41 of the Texas Civil Practice and Remedies Code. The trustee argues that Chapter 41 does not apply in this case, but he does so in reliance on the Xerox case of the Texas Supreme Court. Xerox is in a different position because the statute with the civil penalties in Xerox is among the 4 enumerated exceptions within Chapter 41. Chapter 41 says it applies to all cases except for 4 specific statutory exceptions. Prompt pay penalties are not among the 4 statutory exceptions. The court also addressed this in the Stidham v. Auckland Loan Servicing case, concluding that a plaintiff could not recover civil penalties under the Texas Property Code absent proof of actual damages, and applying Chapter 41. Likewise here, Little River and the trustee would not have been able to recover exemplary damages under the prompt pay statute, but for the award of actual damages, money Blue Cross failed to pay. So the statutory penalties are both damages, and they are not money Blue Cross should have paid Little River.
Counsel, is it, with respect to this issue, I thought the Forte cases that you rely on were limited to the Texas Optometry Act. Am I wrong about that, or does it not matter with respect to your prompt pay argument?
So on its face, the Forte cases are limited to a single act. If you look at the dissent in Forte, it points out that while the majority says it only applies to optometry, there's really not an argument why it wouldn't apply across the board. And then when you move on to the Xerox case a few years later, the court does say that it applies across the board except for the 4 specific exceptions. Thank you. The next category is the uncollectible patient responsibility. I don't think there's really any debate or question that it is a form of damages. The question is whether it is direct or consequential damages. I think it's a really close call under a traditional legal definition.
Tell me why that is. I was going to ask you that. Absent the parenthetical definition, are the patient responsibility damages traditionally, would they be considered consequential damages?
I think they are, but I do agree it's a close call. So for something to be direct damages, it must flow necessarily from the breach of contract. Here you've got a separate contract. The initial contract in every healthcare service is between the doctor or the healthcare provider and the patient. And the fact that the patient has insurance may relieve the patient of some or all of their liability, but the patient's obligation to the provider does not arise out of the contract between Blue Cross and Little River. It arises out of the contract between the patient and the healthcare system. So when Blue Cross fails to meet its obligation, Little River still has the right to collect from the patient. That did not happen in this case, but it could have happened. It was not a necessary result that Little River failed to collect. So I think even under a traditional legal definition, due to the collateral contract, it is still consequential damages. And of course, in this case, I don't think you've reached that because you've got the parenthetical. And the parenthetical was specifically added to avoid any ambiguity, and it provides that direct damages are limited to money the arbitrator finds Blue Cross should have paid Little River. And the arbitrator explicitly says this is not money Blue Cross should have paid Little River. It's money that the patients should have paid Little River. And she says it pretty much in those exact words. In fact, to quote Justice O'Neill, she says, patient responsibility refers to co-insurance deductible amounts and non-covered services that the subscriber, rather than Blue Cross, is responsible for paying. The final category is prejudgment interest. And Judge King in the bankruptcy court ruled that prejudgment interest was both a form of damages and not money Blue Cross should have paid Little River, and awarded a contingent fee. The Texas Supreme Court has consistently, quote, consistently viewed prejudgment interest as falling within the common law meaning of damages. The debate here surrounds certain categorizations within the arbitral award. Little River asked for an award of interest as damages based on its cost of capital, 12%. As a fallback, Little River asked for interest under the Texas Finance Code at 6%. Little River received neither of those things. Rather, Justice O'Neill awarded interest, in her words, under the common law, citing and quoting Kavanaugh at 5%. Under Texas Supreme Court precedent in Kavanaugh and Johnson and Higgins, any award of interest under the common law is an award of interest as damages. Justice O'Neill's section headings, I would say, are dicta, certainly not necessary to the decision, and don't change the nature of what she actually awarded. I will give back the rest of my time.
Okay, thank you very much. Let me just ask a question. Am I correct that your office traveled from Austin to New Zealand to Puerto Rico?
You are, Your Honor.
Interesting. All right, Ms. Nitsch.
May it please the court. Applying the arbitrator's ruling to the amended fee agreement, the bankruptcy court got it absolutely right as to its interpretation of the fee agreement and denial of a contingency fee to Downton on, first, the statutory prompt payment penalties, second, on damages that were caused directly by Blue Cross's violations of its own terms of its contract with Little River, and third, its rejection of Downton's equitable arguments. The bankruptcy court only erred with respect to a discrete fourth issue, its conclusion that prejudgment interest qualifies for an award of consequential damages. Contrary to the text of the arbitrator's ruling, an explicit denial of consequential, punitive, and interest as damages, and Texas law. Today I plan to focus my time on the interpretation of the amended fee agreement and why the amounts awarded in the arbitration do not qualify for a fee award, before briefly turning to my opponent's equitable arguments. Under fee agreement, Downton's contingency fee was limited to 10% of any award for consequential or punitive damages recovered in the arbitration. Consequential and punitive damages were then further defined as all damages other than direct damages. But the use of conditional logic in that definition doesn't really add much to the term's meaning because those categories are mutually exclusive under Texas law. So put another way, if we were looking at this on a Venn diagram, direct damages would be one circle, direct damages would be one circle, and consequential and punitive damages would be in the other circle, and there'd be no overlap.
Yeah, counsel, this is Judge Duncan. What's the function of the parenthetical then? I'm inclined to read the parenthetical as shrinking the Venn diagram circle of direct damages and enlarging your Venn diagram circle of consequential damages. Otherwise, I don't understand the purpose of that parenthetical.
Yes, Your Honor. The purpose of the parenthetical was to provide an explanation or example as to what was explicitly included in direct damages, not to redefine or alter the term's common law meaning. While Mr. Downton cited various online sources in his reply brief representing that parentheticals would use in that way, their purpose is to redefine a term. More authoritative sources, like the 4th edition of Garner's Modern English Usage, make clear that parentheses can also be used to provide an explanation or example, as they were here, and that their use alone doesn't carry any particular legal significance. The conclusion that parenthetical didn't redefine the term direct damages can also be confirmed independently by the court in 3 ways. First, the application to amend filed with the bankruptcy court, and that's in the record at 666 through 667. In the application to amend, the representations made to the bankruptcy court was the only modification to the amended fee agreement was the reduction or deferral in the hourly fees, plus the addition of a second contingency fee. Second, it can also be confirmed by the language of the amended engagement letter itself, which is in the record at 677. The amended engagement letter itself only speaks again about that second contingency fee and the deferral of hourly fees as in terms of what's being modified in this agreement. And then third, this conclusion that the parenthetical didn't alter the common law meaning of direct damages is confirmed by the party's own testimony, including Downton's admission during the evidentiary hearing before the bankruptcy court that the meaning of the terms did not change between the agreements, although the original agreement did not contain that same parenthetical. And that testimony is in the record at 1162. Because words control over punctuation, and the circumstances here, without altering the language of the agreement, make clear that this was an example rather than a definition. This court should give direct damages its ordinary meaning, just like the bankruptcy and district courts did.
Counsel, Judge Duncan again. If I disagree with you, I'm not saying I do, but if I disagreed with you on that point, in other words, that the parenthetical is merely an example, if I thought instead, no, it's defining the term, does your position with respect to the patient responsibility payments then fail? Because those payments are not money that BCBS should have paid to Little River.
No, Your Honor, it doesn't fail for 2 alternative reasons. One, because it does fall within that broad language, as in the way that the arbitrators defined these patient responsibility damages. They necessarily were announced that Blue Cross should have paid Little River because Blue Cross failed to tell Little River what it needed to bill patients within the year time period. And then second, even if the court disagreed with that, the court could affirm as to the patient responsibility award on res judicata or issue preclusion grounds. So this brings me to why...
How can you do that? How can you do that? You don't have the same parties.
Issue preclusion, we believe, would apply here because mutuality isn't required, but privity is. And there is privity between Downton and his client. we cited in our brief a number of cases out of other circuits that have found in similar situations that privity needs to exist between an attorney and a client when they get in subsequent litigation over the first litigation where the attorney represented that same client. And there's a good reason for that. It's because if you didn't have that, you have a situation where you have a second litigation in any fee agreement that was non-traditional, where the attorney would then take positions, could be incentivized to take positions opposite to their client.
But Justice O'Neill said she was not deciding the issue of attorney's fees.
And that's correct, Honor. She was very explicit that she wasn't describing the issue of attorney's fees. And so I don't think, though, that should be read as broadly as to say she was disclaiming any idea of privity. And as to, there is no...
Did anyone offer the attorney fee contract in the arbitration?
Your Honor, I was not counsel in the arbitration. I'm not sure if the agreement was actually provided to the arbitrator. I believe it may have been. She definitely did have it before her, because when you read that portion of the award when she talks about attorney's fees, she acknowledges what it says according to Little River's briefing. But and then she goes on to specifically say, this is not determinative, has no effect, and in fact, specifically calls out, I think at the beginning of paragraph 182 of the arbitration award, says, I can't even shift contingency fees under Texas law, and what I'm going to do here is I'm going to do a lodestar analysis. And in her lodestar analysis, she took down what Downton's hourly fee would be plus the reasonable hours worked, and said this comes out to, with the reduction, it's 1.6 or 1.7 million. And then in that single sentence where she did say, well, a portion is the hourly fee and a portion is the contingency fee, the only way she arrived at that was she just subtracted out what the bankruptcy estate represented. It had already paid Downton about $500,000 in hourly fees. There's nothing in there that suggests she interpreted or applied the terms of the contingency fees in deciding her attorney's fee award. This brings me back to the statutory prompt payment penalties. These are excluded from the scope of Downton's contingency fee because they're penalties and not damages. We believe the Xerox case is positive on this issue, and it certainly did not say that Forte or Chapter 41 applies across the board. It was very specific that it was addressing the ordinary meaning of the term damages and holding that penalties are not damages when they have certain characteristics. The characteristics of a penalty are fixed amounts, not dependent on the actual loss suffered. And the amounts awarded for the Texas Insurance Code violation have exactly these characteristics. They apply whenever a processing deadline is missed by an insurer without regard to the actual loss caused by the contract. And I don't think Downton disputes that's how the Texas Insurance Code provisions operate here. Chapter 41 in the Walmart or Forte case just have no application. There's no contention that the fee agreement imported Chapter 41, what has subsequently been referred to as special definition of exemplary damages, which expressly defines exemplary damages to include penalties. So because penalties are not damages, that's also why the arbitrator was correct when she stated consequential and punitive damages were going to be denied for Little River in the arbitration. Looking at that patient responsibility award of $17 million, that also fits squarely within the meaning of direct damages that Downton can't recover because these damages were the necessary result of Blue Cross's breach of express obligations under its contract with Little River. And that contract actually between Blue Cross and Blue Shield is in the record here at 803. I believe it's Article 6, Provision C of the contract. The arbitrator explains that the Blue Cross contract with Little River provided that Little River had to bill insurers their share within 1 year of the date of service. It's common sense that if Little River's inability to pay patients was prevented by Blue Cross failing to tell Little River what it needed to bill patients, that it would be the necessary result that Little River was unable to pursue collections within that 1 year period. My opponent has asked the court to take judicial notice of Little River's right to supposedly independently collect these penalties, saying that Little River could have chosen to bill patients anyway without knowing what those patient responsibilities are or were. But this is the exact opposite of what the arbitrators found. The arbitrators' findings were very clear that patient billing could not occur without the claim being processed by Blue Cross first. And I quote here what she said, "Little River was unable to properly quantify the patient responsibility amount and thus could not pursue collections from patients."
Well, wait a minute. Is it Louisiana statutory law, or is it something in the Blue Cross or other contract that provided a 1 year deadline for Little River to bill the patients?
It's something in the actual Blue Cross contract that provided it. In that contract, there's several versions of the Blue Cross contract that were at issue in the arbitration and are attached, I believe, in the record, and we're starting around 803. But specifically at Article 6, subsection C, it was a specific requirement of this contract that Little River had to bill patients within a year. And no matter how much Downton dislikes these findings of the arbitrators that the patient responsibility amounts had to be adjudicated by Little River or by Blue Cross before Little River could bill patients, he can't rewrite them through this litigation because the arbitration is final and the contract Downton drafted tied his contingency fee to the amounts awarded in the arbitration, meaning his recovery is inseparable from the arbitrator's findings. Turning then to prejudgment interest, which is the subject of the trustee's cross appeal, the prejudgment interest awarded in the arbitration doesn't qualify as consequential or punitive damages for two reasons. One, the arbitrator's explicit denial of interest as damages. And second, Texas law holding that prejudgment interest is not considered damages. Again here, Downton is stuck with what the arbitrator said and decided as to the denial of interest as damages. She wrote at length about the distinction between interest as interest versus interest as damages, but ultimately denied the recovery of interest as damages, as well as consequential and punitive damages in the text of her award. This eliminated the predicates for a fee award under the fee agreement because those damages were not then awarded in the arbitration. But even if the bankruptcy court could have redecided this issue, prejudgment interest awarded here doesn't fall within the ordinary meaning of damages. And I'll acknowledge here that the Texas Supreme Court precedent on this point is extremely complicated and nuanced. But the trustees submit that the most relevant decision on the topic is the In Re Null case that we discussed in our brief. It interpreted the plain meaning of the term compensatory damages and stated attorney's fees like court costs and prejudgment interest are items that are simply not damages. This case was not limited, although it occurred in the supersedious bond context, it's not limited to the supersedious bond context. And in fact, in the Xerox case, I believe in footnote 72, the court acknowledged the kind of broad holding of null, saying that it pointed out that interest is not always damages. The arbitrator correctly understood and implied these complex distinctions, many of which occurred during her tenure on the Texas Supreme Court, between interest as a true damages element versus interest on underlying damages, when she denied Little River's request for interest as damages. Accordingly, we believe the court should reverse as to the prejudgment interest award on two independent bases. One, the issue preclusion, or under the terms of the contract because interest damages were not awarded in the arbitration, or under the interpretation of the contract in Texas law. Finally, the bankruptcy court I'd like to turn to the equitable argument here. The bankruptcy court heard competing evidence, assessed credibility, and properly denied Downton's equitable claims. The court should affirm this rejection because Downton cannot show an abuse of discretion and hold Downton to the plain terms of his contract. To prevail here, Downton needs to show not only that the law supports his claim, but evidence as to each element and that it was clear error for the bankruptcy court to take a contrary view of the evidence. He hasn't met that burden, particularly as to the bankruptcy court's assessment of competing evidence. The bankruptcy court was entitled to believe the trustee's testimony that he expressed to Downton that he would not be receiving a contingency fee beginning in January 2020 and again at various other dates. The trustee also testified that he never solicited Downton's employment and never asked Downton to relocate from New Zealand. And that's in the record as in the testimony heard on the fee application at 1165. The record evidence also reflects that Downton himself advocated that the trustee should pursue fee shifting from Blue Cross and other entities, all while still aware that the trustee's position was that no contingency fee was due from the estate. And that's in the record at 1174 and 1175. In addition to this competing evidence, the bankruptcy court was correct in rejecting Downton's claim of judicial estoppel because, as I discussed previously, there was no clear inconsistency. It was clearly cabined that this arbitrator was not reaching this issue, nor could she. It would be outside her purview, being under the supervision of another court. Additionally, there was no judicial acceptance. As we also already discussed briefly here, the way she calculated the attorney's fees due did not involve any interpretation of the amended fee agreement. There's nothing in the award that suggests she interpreted it or was applying it when she came up with that $1.6 or $1.7 million fee award amount. And third, the factual circumstances just don't bear out that denying Downton a contingency fee here would be inequitable. The outcome of this case won't result in a windfall to the trustee. His compensation is fixed by statute. Nor would it provide a windfall to the estate. It merely would allow the trustee to pay out at a higher pro rata share of the monies that were left owing to creditors when the debtors under Downton's own leadership became insolvent. In fact, the trustee submits to the court the only person awarding a contingency fee based on judicial estoppel would be a windfall for is Downton, who's now advanced and advocated the legal arguments he's now trying to fold against his own client to obtain a multi-million-dollar award.
Well, he did have a contract, and we're interpreting the contract, so it's pretty hard to say who's equitable or inequitable here.
Yes, Your Honor. My comment there was it would be inequitable under if the court were to award the fee only on equitable grounds versus the contract.
All righty. Any questions, anybody? Okay, we have no further questions. Thank you, Ms. Nitsch.
Thank you, Your Honor.
Mr. Downton, rebuttal.
Thank you, Your Honor. To your question earlier, the arbitrator did have the engagement letter. In fact, she cited it and quoted it in paragraph 171 of her opinion, where she said the bankruptcy court approved the trustee's retention of Mr. Downton as an attorney for the state based on a hybrid-free arrangement that included a reduced hourly rate and a 10% contingency fee on all damages, quote, other than direct damages, which are defined as, quote, money the arbitrator finds Blue Cross should have paid Little River for healthcare services. And then it cites to the docket entry where the engagement letter is located. In paragraph 182, which was cited by Ms. Nitsch.
Well, but the point is, all right, she had it, but she did not interpret it. Is that correct?
No, I think she did interpret it. I think she ruled that it meant what I've argued here and what the trustee argued there, that it was 10% on all damages other than direct damages, which were further defined as money that Blue Cross
Well,
should
then
pay.
why are we arguing about, so you're saying the bankruptcy court was totally wrong?
I'm saying the bankruptcy court was correct in its ruling on prejudgment interest. I think the bankruptcy court erred in its interpretation of the contract for the other categories, yes. With respect to the argument that there would not be a windfall to the estate, I think that's wholly inaccurate. The estate recovered more in attorney's fees than it owed, absent an obligation to pay a contingency fee. That is a windfall. With respect to the Nell case, it did not include any prejudgment interest. That wasn't an issue in Nell. Now is specifically addressing the supersedious bond issue in a case that had no prejudgment interest. It points out that in the supersedious bond statute, prejudgment interest is listed separately. But I don't see any basis to apply now beyond that context. With respect to the argument on privity, you need virtual representation in this circuit, and there isn't any. The law office did not have the ability to control the representation, and the trustee has no accountability back to the law office. So privity simply doesn't apply. Additionally, collateral estoppel wouldn't apply because none of the findings at issue here were necessary to conclude the case. Whether Justice O'Neill calls interest is damages, interest is interest, or simply interest, it doesn't change the amount awarded in it, and wasn't necessary. So with that, I will respect.
Ms. Nitsch, counsel, Ms. Nitsch, as I understood it, argued that with respect to the patient responsibility payments, that absent Blue Cross, processing of the payments, the patient responsibility payments couldn't have been sought. In other words, there's a necessary, in order to make the argument that they're an aspect of direct damages. Is that correct in terms of the mechanism of seeking the patient responsibility payments?
I think it's inaccurate. Blue Cross did adjudicate these claims. Little River's position was that it adjudicated them incorrectly. So Little River could have gone ahead and billed the patients on receipt of the adjudication, even though it disagreed with it. Could have then collected from the patient and still sued Blue Cross, and then may have owed the patients a partial refund. But mechanically, Little River could have pursued the collections before going through the arbitration.
Thank you.
Thank you.
All right, thank you. That concludes the first case of the morning. Goodbye, Ms. Nick.